Back for another Red Shirt Friday weekly recap of the Oregon standoff trial. I've been on the radio again with my friend Trent Luce this morning on Rural Route Radio discussing this, and so I want to basically pick up where we left off and kind of not just give a weekly recap, but basically give an assessment and some commentary about where the case stands at this point after 4 weeks of trial in Portland. So I've analogized this case before to a three-ring circus, but actually this week, and after I've given it a lot of thought, I think that it actually is more like a six-ring circus. And I want to start out by explaining what those six rings are. I mean, literally, it's a six-ring circus. And the first ring is the prosecution. The second ring is the defense. The third ring is the judge. The fourth ring is the jury. The fifth ring is the media. And the sixth ring is the American public. We're spectators in the case. And I want to start out by talking just a little bit about that sixth ring. From my perspective, in this country, the entire country, recognizing that there are probably more in Oregon and in the West who are paying attention to this case, but in the entire country, I would venture to say that there are at least 80% of the general American population who don't even know that anything happened in Oregon in January and February of this year. They don't know that a trial is going on. They don't know anything about the Oregon standoff, and they don't really care. That leaves less than 20% who really are even aware of it, let alone care. And of that 20%, it's probably a very small portion who really care, who follow it very actively on one side or the other. And so that's one of the points I want to make, is that there are those who are following the case very closely. It's a very small number of people in the overall scheme of things that really care a lot about the case. And the people who do cover the full spectrum. On one side, you've got those who are very adamant supporters of the Bundys, if you will, or the occupiers, or the ideology behind that, which includes basically perceptions about how public land should be managed. And on the other side, it's the opposite side of the spectrum with respect to ideology, but largely with respect to the same issue, which is management of public lands. And from my perspective, a lot of the people on that side of the spectrum probably come from a more urban background to a large extent. They often represent environmental preservation ideology, and they would like to see all ranchers, all livestock removed from the public lands or the federal lands in the West. I see that all the time. I see that ideology being espoused by the very vocal minority who are adamant about what should happen in this case. And they argue all the time that there shouldn't be any cattle anywhere in the West on the federal land. They, from my perspective, ignore three basic points. And that is that the Federal Lands Policy Management Act basically makes 3 points. It says that the act itself is subject to all valid prior existing rights. It says that the federal government must coordinate with local governments, that's state and local governments, in its management of federal land and resources. And finally, the federal government is mandated by statute, by Congress, to engage in multiple use and sustained yields on the federal lands. And so, despite those statutory mandates, they would still like to see all cattle, all livestock, all ranchers removed from the West, basically. And so that kind of sizes up the sixth ring in the circus. 80% of whom aren't even aware of it, 20% of whom are somewhat aware, and then you've got a small fraction of people who take a strong position on one side or the other, and then there's everything in the middle. So now let's go back to the first ring in the circle, which is the prosecution. I don't see the point of saying a whole lot about. We've talked about the prosecution quite a bit in the past as they've presented their case. From my perspective, as I size it up, I think they did a very good job. They were very efficient about their presentation of the case. They're very well prepared. They were very well organized. They got in, they got the job done, they rested. The problem is the case, the evidence that was actually admissible in court was very marginal. The evidence that came in, and I'm going to say this, if you compare, and I've said it before, with what they said in their opening statements versus what they presented as evidence in the case, I would say they overpromised and underdelivered. They weren't able to present the evidence, strong, compelling evidence in terms of a case against the defendants in this particular case. So I think that's got a lot of people right now really biting their nails. They're pretty worried. So that causes them to really try to do everything they can and to fight real hard to keep out the defense evidence. And I think on the other side of the spectrum, I don't think the defense has been near as well prepared, near as well organized. I think they've struggled, especially this week, to be fully prepared, to have witnesses ready to testify. And while they were trying to have witnesses ready to go and on the witness stand, something was going on behind the scenes during a lot of that time when there were evidentiary hearings and arguments. They weren't ready to put Ammon Bundy on the stand yet because they wanted to get some rulings from the judge about what would be allowed, what would be admissible in terms of videos, in terms of photographs, in terms of exhibits. And so some of the time they were just trying to find people to put on the witness stand while they cleared up some of those issues. And they ended up having some real challenging discussions between especially Attorney Marcus Mumford and Judge Brown. But at the end of the day, and I'll talk more about the third ring, which is the judge, in just a minute, but in terms of the defense, I think at the end of the day, they were able to get Ammon Bundy's evidence presented quite cleanly. And one of the biggest parts of that evidence, and he testified everything about his upbringing, his background, why he went to Oregon to support the Hammonds, why he felt strongly about that. But one of the most important components of that testimony and that evidence was the fact that he claimed that he went to the refuge to stake an adverse possession claim. And I know there are a lot of people who've said, that's just not true. He made that up after the fact. He made that up after talking to the attorneys. They're just trying to come up with that. But the defense was able to present a lot of evidence in addition to Ammon Bundy's testimony to the effect, this included videos showing that he was teaching ranchers and other locals at the refuge about the principles and concepts of adverse possession. He was teaching them what the component parts were and what needs to be done. Exhibits were presented as evidence that showed adverse possession, written at the top of a whiteboard, and bullet points showing what the component parts are. And all of those things, of course, supported Ammon Bundy's testimony in that regard, because his position was that he was there not to interfere with or impede federal officers. He was there to stake an adverse possession claim. He didn't think, he testified, that he was doing anything unlawful. He didn't feel like he was doing anything that was criminal. He thought at most the federal government might claim that he and his associates were in trespass and that they would undertake a civil action to evict them from the refuge. And he says that they brought guns so that they could be taken seriously, so that they could defend themselves if necessary, and so that they could also have an opportunity to protect their other First Amendment rights. That's basically what he said. So that was the defense's case in a nutshell, and I think once that evidence came in as cleanly as it did, without even a lot of room for serious cross-examination, the prosecution cross-examined Ammon Bundy for less than 20 minutes, after which Jeanette Finicum testified about Lavoy Finicum's involvement, the fact and what she had done, and the fact that she had been trying to convince him for the full first week of the occupation to actually return home. And that was what concluded the trial week, was Jeanette Finicum's testimony. She said that in the end she resigned herself to the fact that Lavoie, once he got there, once he saw what was going on, he was committed to stay. He wasn't going to leave until the job was done, basically, of trying to protect the ranchers in Harney County, to teach them about adverse possession, etc. Ammon Bundy testified that his exit strategy basically was to teach these local ranchers about these principles of adverse possession and what should be going on from his perspective. He wanted to teach and work with the Harney County Committee of Safety, and then his plan was to basically turn that whole thing over to them, turn it over to the locals, and he and his associates would pull out. They would leave, but someone else would step into their shoes in terms of taking possession of the refuge based on the principles that he was advocating. That was his testimony. So that's the defense ring. Then we've got the judge, of course, Judge Anna Brown, and I've talked about her at some length. I've written about her. I think this week it became more obvious than it ever had been before just how biased she is. And I think even she began to realize that as she really started to realize, because Marcus Mumford challenged her on the inconsistency of many of her evidentiary rulings. And when he did that, and they had some very testy exchanges, but at a certain point in time, even Judge Brown, I think, had to back up and realize the inconsistency and just how thin a ice she was on. And so she actually relented on some of her previous rulings and allowed things to come in that she had previously said she wasn't going to. And I think the reason she did that is because even she realized how thin the ice she was on. And so that's the judge. Now we've got the biggest mystery in the whole case. It's the ring that involves the jury. The jury, we've seen the prosecution, we've seen the defense, we've seen the judge, we see the jury, but we don't know what they're thinking. We don't know how they're assessing and processing this information. We don't know how they're assessing credibility and motives and everything that's going on. And of course, the judge tells them all the time, you can't listen to any other information other than what is presented here. You can't talk to each other about the case. You can't talk to your family or friends or anybody else. You just have to store this information in yourself, and then when we do turn the case over to the jury following closing arguments for you to deliberate, then you assess it, then you deliberate, then you come back with a verdict. And so that's the real wild card in the case at this point. From my perspective, the government put on a very marginal case. From my perspective, the defense actually put on a pretty darn good case, and it came in very cleanly, even though it was a little bit hard to watch how they were going about doing that, and what the government and Judge Brown were trying to do to interfere with that and prevent it from happening. But you've got to ask yourself whether or not the jury can see through all of that. So then that brings us to the fifth ring of the circus, and that's the media. And I'm part of that. I'm trying to take an alternative media, independent media role in an attempt to bring another perspective to the table. It's always been my position that there are always multiple sides to every story, including this one. And if the only thing you hear or see or read is what the mainstream media is saying, my concern is that you're getting a very slanted perspective on the whole thing. And so we feel like it's important that you have the opportunity to hear other sides of the equation. And one of the reasons that I haven't continued to be in Portland is while I was there the first time, I was actually served with a subpoena to testify in the case, and I thought that was going to be happening next week. So I backed away from Portland. I came back home to catch up on some things and to not be in a position where I would be interfering with my subpoena by being present in court, that sort of thing. I was just informed late yesterday that I was going to be released from my subpoena, and I think a lot of other witnesses have been and probably will be as well. And I think that's a sign that the defense feels like its evidence came in cleanly enough through Ammon Bundy that it probably doesn't need to look to as much of the other evidence as maybe it was counting on. My primary role as a witness was probably going to be to testify about the efforts that I went to help try to resolve the case. I was asked to go by the Finicum family, and I'm going to talk more about this in another video clip, but they